Hello, everyone. My name is Alexander Nam, and I'm a law clerk here at Lowes Parker. Welcome to today's webinar, hosted by the Home Care Association of Louisiana. Today's webinar is entitled Home Health and/or Hospice Agencies Business Relationships with Sources. Today's presenters are Ashley Morgan and Jennifer Papapanagiotou. Ashley Morgan is a partner in Lowes Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion/termination issues. She has worked with an assortment of providers, including home healthcare companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. Our next speaker, Jennifer Papapanagiotou, focuses her practice on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws, and drafting a wide variety of legal agreements. She is knowledgeable in all aspects of state licensing for home health and hospice providers, and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. A quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box and we will address them, as many as possible, at the end of the presentation. Without further ado, I present to you our speakers for today's presentation.
Thanks, Alex. This is Jennifer Papapanagiotou. Welcome, everybody. Appreciate you joining us today. Let's go to the next slide, please. We're going to spend some time working through and talking about some of the major laws that apply to relationships with referral sources. And just a disclaimer at the beginning, this is just general information. It's not legal advice, and it shouldn't be used as a substitute for counsel. If you have specific questions that pertain to your business, we highly recommend you visit with your attorney or with an experienced healthcare attorney. Let's go to the next slide. So we're going to first cover just some examples of the types of relationships that create risk in this particular area, this business relationship area. We're going to go through at a high level the major federal laws that apply. We're going to look at some of the interpretive guidance that's out there about how these laws are actually being applied in practice and what you can do to craft compliant arrangements within your organization. Let's go to the next slide. So, examples of problematic practices. These are relationships that have been flagged by enforcement authorities, whether that's the Office of Inspector General with HHS or other law enforcement type authorities like the Department of Justice. And just two problematic practice areas that that we see over and over and over again that we are asked by clients to provide advice on, and that's relationships with physicians and relationships with marketers or community liaisons. So problematic practices are things like sham medical directorships, where physicians are paid for no services or they're overpaid for services. And oftentimes we see scenarios where there are enforcement risks when you have multiple medical directorships with compensation that's based on volume or value of referrals or some other metric that isn't consistent with what's permitted under the law. With regard to marketers, oftentimes, and these are kind of vary from situation to situation, but marketers are often either compensated inappropriately if they're not employees of your organization, or you have incentive arrangements even with employed marketers that are inappropriate and can result in all sorts of problematic conduct, like marketers who are giving gifts to referral sources or directly to patients, or encouraging or participating in business relationships with potential referral sources, like setting up space rentals in facilities, that may have potential referrals. That's not necessarily a marketer's job, but it certainly is something we've seen in the context of marketing between agencies and facilities. Let's go to the next slide. And then the next big category where we see problematic arrangements are between agencies and facilities directly. Things like agreements with nursing homes to send patients to the agency, excessive rent for agency space within a facility, whether that's assisted living, skilled nursing, regular nursing facility, free or below market value services provided by, for example, a hospice to a nursing home, referring a home health or hospice patient in exchange for that nursing home, then referring that patient back to the agency, or agency mining of medical records in a facility to identify potential patient referrals without patient permission. Those are just some examples. We've seen those flagged in fraud alerts that have come out from the Office of Inspector General. We've seen them in enforcement actions, in inspection and investigation reports, but we've also seen them from clients that have brought, various either concerns that they have or proposals that have been made, and they want us to evaluate or opine on those. So let's look at a few example cases. Let's go to the next slide. The probably bellwether case for home health, anti-kickback type statute problems, False Claims Act type statute problems, that presented, quote, issues with potential referrals, business relationships, referral sources, is the Jacques Roy case. This was a huge, huge case that it actually originated before 2017, but 2017 sort of when the litigation was happening. Just give you some context, Dr. Jacques Roy was a physician in the Dallas-Fort Worth area, and he had referred more than 11,000 patients for home health services and had some affiliation with over 500 home health agencies in the state of Texas. The home health agencies would identify potential patients and refer those patients to Dr. Roy, who would then sign certifications for home health and refer them back to the home health agency that had originally identified the patient. He had obviously some financial relationship with those agencies where he was compensated for those referrals. And he had obviously these agreements with multiple home health agencies. In addition, the agencies he was affiliated with had inappropriate marketing practices where they were driving around Dallas and identifying people in homeless shelters, and other, door-to-door at apartment complexes, et cetera, and offering potential patients incentives to sign up for home health services, essentially to give over their Medicare ID credentials so that they could become a home health patient. And in exchange, the patient would get money or gift cards or other incentives to participate. Statistically, the government ultimately identified this case through what they call data mining. And they were looking at the volume of Dr. Roy's referrals and the numerous numbers of agencies he was involved with. And then they started sort of digging deeper. And some of the home health agencies that he was affiliated with had over 80% of their patients referred or, ultimately certified by Dr. Roy. His office handled more home health visits than any other physician's office in the country. And obviously with that volume, they ultimately discovered that he was having employees fraudulently sign his name to plans of care and certifications when he had never even looked at a medical record or ever seen the patient. The OIG, just for context, said that most physicians who refer patients for home health services refer fewer than 100 patients a year. That actually is a large number in my experience, but depending on the kind of physician, if it's someone who does a lot of geriatric care or certain kinds of patient populations, you can see a higher volume of home health referrals, but your ordinary internal medicine physician is never going to refer 500, 11,000 patients over the course of several years. When Dr. Roy's practice was first identified as an issue in association with these home health agencies, he attempted to go around the investigation, and he created a second practice, which then paid management fees to the original practice. This was just a way to shuffle money around and to try to avoid the government investigation. Ultimately, the government viewed that as obstruction of justice and added some extra charges to his indictment as a result of it. This was a highly investigated and ultimately litigated case that he took to trial, and he was ultimately convicted and sentenced to 35 years in prison. Other people that participated in the scheme were also, and it included home health owners, marketers, and other people within his medical practice, and they were convicted and sentenced to between 3 and 17.5 years. So very significant home health enforcement case. He was also ordered to pay $268 million in restitution. So the Jacques Roy case really kind of threw home health enforcement into the spotlight. It involved a ton of home health agencies in Texas and obviously some really high dollars. And although there was certainly home health enforcement before this case came along, the volume of enforcement activity in home health since this case really, began has just escalated exponentially. So let's go to the next slide. This is another example. This actually involved a hospice agency in Missouri, and it was happening around the same time as the Roy case. This particular agency was based in Oklahoma City, but it had offices and provided services in a number of states. And this ultimately was a civil case that was brought by a whistleblower. We'll talk a little bit about whistleblower cases later on, but you've, I'm sure, read about them, heard about them. It's essentially, the False Claims Act includes a provision that lets a private individual bring a lawsuit for violation of healthcare fraud laws on behalf of the government. And in exchange for successfully prosecuting a case like this, the whistleblower can receive a percentage of whatever money is recovered by the government. And it's a unique statute. It was conceived of back in the Civil War to allow private individuals to essentially report defense contract fraud. And it's been used extensively and is probably the largest proportion of whistleblower cases in the country are healthcare whistleblower cases. In this one, the whistleblower was an executive director of one of the offices that was involved in this scheme. And not really even an executive director for very long. This person was only there for about 6 months. What the whistleblower observed, however, was that the hospice was hiring medical directors based on the ability to refer patients, and they were focusing specifically on medical directors with ties to nursing homes. Each hospice would have 4 to 5 medical directors who worked maybe 2 hours a month and were receiving about $3,000 a month in salary. And if you do the math on that, that's about $1,500 an hour, which is probably excessive for any medical director anywhere in the country. The hospice required medical directors to refer at least 1 patient a month to the agency or they'd lose their position. One medical director was actually terminated for failing to bring in referrals, and even though he subsequently expressed concern about the quality of care as the reason for not referring to patients, and the hospice would keep at least 1 patient in a nursing home as a hospice patient, so they would have access to the nursing home to continue marketing their services. So a lot of problematic arrangements here, medical directors being overpaid, being required to make referrals in order to receive pay, big no-no. And the incentive arrangements that were being entered into with facilities to encourage the facilities to continue to refer to them. Let's go to the next slide. There were a few other problematic arrangements here. Hospice nurses also performed the work of nursing home nurses when they were in the facility. This is just an example. The hospice would agree if the nursing facility would give them 5 patients, then they would hospice would pay for a nurse aide to be in the facility all day long and work on things other than hospice care. Equipment that was being provided free of charge, paying for room and board even if they didn't get paid. The hospice didn't get paid. Giving gift baskets and free lunches and other things to the nursing facilities in order to incentivize referrals. Ultimately, Good Shepherd settled the case for $4 million, which honestly, in the scheme of things, sounds like a low number to me, but they also received a 5-year corporate integrity agreement with the Office of Inspector General. So this is another example that included a lot of business relationships that were problematic. And this is sort of the examples that we talked about earlier. Let's go to the next one. We'll just cover one more case. This is the US v. DeBoer and Whitaker case. This is from the 2018 time period. This involved a registered nurse that owned a company And DeBoer, who was the owner of the company, and Whitaker, who was one of the other individuals involved in running it, paid group homeowners for access to and for referring Medicare beneficiaries. They were paying the group homes $500 for an initial certification and $250 for a recertification. And they were making those payments both in cash and by check. They were also paying marketers and recruiters to find beneficiaries for them, and then the beneficiaries were paid to sign blank home health forms, basically admission type forms. This was a criminal case. Ultimately, DeBoer was found guilty at trial and sentenced to 9 years in prison and ordered to pay restitution. So this is just another example of kinds of problematic relationships that have been prosecuted in the past. So now that we kind of understand some of the problematic arrangements folks can find themselves in, what not to do, let's talk a little bit about the laws. Let's go to the next slide. And we can actually go to one more after that. Just some background so you have a little bit of context. Healthcare spending obviously has been under tremendous scrutiny for a number of years now. And that has spurred increased regulatory enforcement by both federal and state healthcare program officials. It's really only gotten more intense since 2010 when healthcare reform legislation was passed. They increased some of the penalties and made some modifications to some of the laws, and the funding by the Department of Justice in particular to pursue enforcement activity has really, really increased over time. And so, we've seen formation of and funding for the task force type organizations within DOJ, which are like multi-agency task force that are out looking for healthcare fraud in certain jurisdictions. So it's well funded. The people who are involved in these investigations have become much more sophisticated. They leverage outside consultants who have a lot of expertise in healthcare business to help them with these investigations. So it's just become more intense over time. When you think about the level of enforcement activity, we also have to understand that the regulatory and statutory requirements in healthcare are incredibly complex, and it is difficult for the average business owner to really keep their finger on the pulse of what's going on the enforcement side. And because of that, you really need a partner to help you through these arrangements. And we cannot stress enough how important we think it is for agencies of any size to have healthcare counsel. And when I say counsel, I really do mean somebody who understands healthcare and has some experience in evaluating compliance of different business relationships with healthcare laws. It's not something to turn over to your real estate lawyer or your divorce lawyer. It's not something even a general business lawyer is necessarily going to have the expertise necessary to really advise you. Healthcare law and the number of folks practicing and in that area of sort of expertise has certainly increased over the years. It's easier to find people with this expertise, whether it's our firm or someone else. We just highly recommend to folks, if you're looking at even just a medical directorship arrangement, how are you paying marketers? What kind of incentives are you giving? You really do need legal counsel to give you that extra layer of protection when you're looking at these types of arrangements. Let's go to the next slide. Criminal prosecutions for healthcare fraud have been really active, and we've seen over the last several years, the Department of Justice, when they open a civil investigation, they automatically have the criminal division look at the case. It's a policy internally now within DOJ. So we are seeing civil cases converted or have companion criminal cases. In addition to that, there's been directives put out from the Department of Justice that whenever they're looking at a criminal case, they are not looking at just the organization or the entity that's involved. They want accountability from individuals within the organization. So it's not just criminal prosecutions in general, it's also a more intense focus on the roles of individual, usually leadership level people in whatever scenarios being investigated. The companion to that is that integrity auditors, the UPICs, have been very, very active, and we continue to see suspensions and revocation actions really have returned to their normal level, I guess, post-COVID. So auditing is very active. I think everybody's familiar with that. TBE has been pretty active, especially in hospice over the last couple of years. Let's go to the next slide. Okay, so I created sort of a laundry list of the big heavy hitters in healthcare law and the laws Ashley and I look at and think about and consider every day when we're evaluating business relationships. And they kind of fall into two categories. There's the criminal laws and there are the civil laws. And these are the federal laws that apply. Criminal laws, the primary one that we focus on is the anti-kickback statute that deals with payments for referrals. And that's a broad overgeneralization of what that law says, but just keep in mind, it drives a lot of criminal investigation and enforcement activity. It kind of goes hand in hand with several of the others that we've listed here, including the False Claims Act. Years ago, they modified the False Claims Act to essentially say that if you violate the anti-kickback statute, every claim that's filed that is tainted by a relationship that violates the anti-kickback statute is automatically a false claim. So when you violate the anti-kickback statute, you automatically have a companion violation of the False Claims Act with the penalties and fines that can be assessed under that law as well. So lots of these go hand in hand. I also have to mention the criminal healthcare fraud statute, which is 18 U.S.C. 1347. We are seeing that used more and more in criminal cases because they can bring in conduct that does not necessarily involve the Medicare or Medicaid program. 1347 essentially is a general healthcare fraud statute that can apply even in the private insurance context. So we're seeing more and more cases. Anti-kickback statute only applies when the fraudulent conduct involves Medicare or Medicaid or governmentally reimbursed programs. Criminal healthcare fraud statute does not have that limitation, so it's a little bit broader. From a civil law perspective, the three laws we worry about most are the Physician Self-Referral or Stark statute, the False Claims Act, and HIPAA. HIPAA, while it includes a whole bunch of stuff about privacy, also has some enforcement provisions in it. That primarily have to do with civil money penalties and other ways they can punish you for violation of law. So we're going to cover two of these in more depth, the anti-kickback statute and the physician self-referral law, so that you have some idea of how these apply kind of in your day-to-day life. So let's go to the next slide. So the anti-kickback statute, as I said, is a federal criminal statute, and it prohibits the knowing or willful solicitation, receipt, offer, or pay of any remuneration in order to induce or reward business that is payable under a federal healthcare program. Now, the important language here is knowing and willful. So this requires a certain intent, and it has to involve at least the offer of remuneration. And remuneration, it could be money. It could also be something, a tangible thing or a benefit that's offered in exchange for a referral. This is generally referred to as the kickback statute. And if we're going to just boil it down, it's you can't pay for referrals and you can't offer to pay for referrals. Both parties to a kickback arrangement are subject to this law, and both sides can be prosecuted. So it's both the offerer and the receiver who can be prosecuted. The types of business relationships that are covered by this law include any business relationship between a referral source and a healthcare provider. And transactions among parties who refer to each other, that can be a medical directorship, that could be an independently contracted marketer, that could be an investor in a healthcare business who may receive a return on their investment that's in any way, shape, or form tied to the referrals that they make. If you're found guilty of the anti-kickback statute, it can result in imprisonment and significant fines. In 2018, they increased the penalties for violations of the anti-kickback statute from a minimum of $25,000. It can range from $25,000 to $100,000 per violation. And the violation generally is a payment. The Balanced Budget Act increased the maximum term of imprisonment from 5 to 10 years. And you can also be excluded from participation in all federal programs if you violate this law. The penalties for violation of the anti-kickback statute, if you compare them to other federal criminal statutes that are similar, are really, really egregiously high. You know, healthcare fraud, you can be put in prison for longer for committing healthcare fraud and find more money for committing healthcare fraud than for committing things like bank fraud, frankly. I mean, as far as white collar fraud goes, this is one of the most punitive statutes out there. we just want to reinforce that this remuneration we're talking about doesn't have to be money. It can often be anything of value. Gift cards, it could be gift baskets, it can be any number of things or anything that does have value. Let's go to the next slide. We should mention that I mentioned on the last slide that this statute requires intent in order to violate it, but the Affordable Care Act back in 2010 actually watered down the level of intent that is required and essentially changed the intent standard to make it easier to violate this law. It's that a person does not need to have actual knowledge of this section of the law or specific intent to commit a violation of this section in order to knowingly and willfully violate it. So you really have to have what we call general intent. You have to just intend to engage in conduct that violates the law. You don't actually have to intend to commit a violation of this law. It's a fine line, it's a legal distinction, but the takeaway from it is that it's much easier for the government to prove someone intended to violate this law than it used to be. We still have what's called the one purpose rule, which came out of a case years and years and years ago that was litigated. And essentially the one purpose rule said that if even one purpose of a business relationship was to improperly induce referral, it violated the anti-kickback statute. That standard still exists, and we use it a lot in evaluating business relationships. When we're thinking about the facts of a particular relationship, what it really forces us to do as attorneys is really push our clients to explain why they need this relationship. What is the purpose of it? And what do you look to get out of it? We need to really clearly define what the purpose of it is and what the specific services are that are going to be provided if it's, say, with a medical director or with an independent contractor. We want to be very clear about those purposes, and we want to document them so that we can build a strong foundation for defending the arrangement. Again, you don't need to show intent to violate the statute, only the general intent to engage in the conduct that ends up violating the statute. So let's go to the next slide. The good news, if there is any good news out of this, is that the fine folks with the Office of Inspector General, when they were writing the implementing regulations for the anti-kickback statute, were told that we need you to define business relationships and practices that don't violate the law, that people out there in the healthcare industry need some guidance and they need some protection that they can continue to engage in everyday business arrangements that don't violate this law. And so the concept and the regulations surrounding safe harbors were created. So the anti-kickback statute is obviously very broad, and in 1987, the Office of Inspector General began issuing regulations that define business relationships that, while they may appear on their face are potentially a violation of the law, OIG would permit those relationships to exist as long as certain safeguards are put in place. And we have something like 25 safe harbors right now. They are voluntary, and the fact that you don't fit in a safe harbor doesn't necessarily mean you violate a law. It just means you have to look at all the facts and circumstances of the arrangement. It is certainly preferable for you to try to fit in a safe harbor. But in order to get protection under a safe harbor, you have to meet every requirement of that safe harbor. The most common ones that we see used in the home health space are the employment safe harbor, the personal services and management contract safe harbor, the space lease safe harbor, the equipment lease safe harbor, and less because home health really, for other reasons, we don't see physician or referral source investment in home health very often, but there is an investment interest safe harbor that sometimes applies. And we do see that particular safe harbor used more for hospice. New safe harbors can be added periodically. We saw several added over the last 4 or 5 years to deal with value-based arrangements. So it's a dynamic area. We also get interpretive guidance and things called advisory opinions that come out periodically from the Office of Inspector General that look at specific scenarios and provide OIG's opinion of whether those particular scenarios violate the law or not. You can request those if you have a new or novel arrangement that you're not sure whether it's acceptable or not. Let's go to the next slide. I want to spend a few minutes looking at some of the specific requirements of these safe harbors, the big ones. Personal services and management contracts is probably the biggest one we deal with. And there are 6 or 7 different requirements you have to meet. So a written signed agreement that covers all the services to be provided has to be for a minimum of a year. The methodology for determining compensation has to be set in advance. They've changed the interpretation of that recently. Has to be consistent with fair market value and not determined in a manner that takes into account the volume or value of referrals or business otherwise generated between the parties. The overall arrangement cannot involve counseling or promotion of a business arrangement that otherwise violates state or federal law. And the aggregate services should not exceed those that are reasonably necessary to accomplish the commercially reasonable business purpose of the services. So again, to fit within the personal services and management contract safe harbor, you have to meet every single element of the safe harbor. The big areas that have changed most recently is the concept that your compensation has to be set in advance. That used to take out essentially any arrangement that didn't include a set schedule for services. They've backed off that, and they've said you don't have to necessarily have a distinct set schedule for services. They've also said that they used to tell us that per service or percentage-based arrangements would never fit within the safe harbor because that we cannot determine the compensation in advance. They've backed off that as well, and they've now said as long as you can determine the formula for compensation in advance, then you would meet this requirement. However, that formula still can't take into account the volume or value of referrals in calculating the compensation. So we've had some changes over the years, and that's a fairly recent change in this particular safe harbor. And it's used to be that medical directorships that were paid on a per hour basis, unless it was, the exception, frankly, rather than the rule. But if I said I was going to pay $150 an hour for up to 5 hours a month, technically that didn't fit within this safe harbor. It now will, and that's a good thing for the provider community. The other area that we focus on a lot when we're evaluating compliance with the safe harbor is the last requirement, that the services being contracted for don't exceed that which are reasonably necessary for the business. This is that scenario where agencies that have been investigated will have like 4 or 5 medical directors for a home health agency, and it's hard to understand why that's necessary. Now, there can certainly be scenarios where that might be something they need, but if you're going to have multiple medical directors, you really need to go to take the extra step and put down in writing, why is that necessary? Why does your agency need that? What special purpose is that extra or 2 or 3 medical directors serving that you really need to be paying for? So we think about that a lot when we're evaluating arrangements. Let's go to the next slide. The space lease safe harbor and the equipment lease safe harbor are both very similar. This does come into play if your home health or hospice agency is going to ever occupy space in another potential referral sources building. So if you're going to have a remote office, like a branch location within an assisted living facility or within a nursing facility. We see this sometimes in certain contexts. If you're going to do that, it's really important that lease be structured to fit within the safe harbor. It's very similar to the personal services. I'm not going to go through this in a lot of detail. Just understand that if you're ever going to enter into that arrangement, or that kind of arrangement, you need legal counsel to look at it with you. And they're going to want it structured to fit within this safe harbor. I'd like to go to the next slide and spend a little more time talking about the employment safe harbor, because we do see this used quite a bit. This is the safe harbor that is used most frequently to protect your employment arrangement with marketers and with community liaison people. Essentially, it's a very broad safe harbor if you follow it, and it provides a lot of protection if you're aware of what it requires and you do a good job of following. It's not hard to meet if you just do it right. So remuneration will not include any amount paid by an employer to an employee who is in a bona fide employment relationship with the employer. And the bona fide employee test is the IRS test that's defined at 26 USC section 3121 D2. interesting, the cases that have been litigated in this area. We've participated in investigations where they've looked at whether a provider complied with the employment safe harbor. And I will say, you really have to be careful how you structure your relationships with folks like marketers and others that are out in the community a lot and don't necessarily work at your physical parent location or branch location on a routine basis. The key factors we have seen that enforcement people look at in these cases and are really interested in when they're evaluating compliance with the safe harbor are: how are they paid? Are they hourly or are they paid purely on commission? Whether they have an office at the employer's location or that they come to the office on some routine basis, whether that alleged employee has received the same kinds of training that all other employees receive. So if you're doing compliance training for your clinical staff or your office staff, there's no reason why your marketers shouldn't be participating in exactly the same training to the extent it's relevant to them. They look at whether the alleged employee set their own hours or were required to work certain hours by the employer and report those hours. And they look at whether the employer paid all the expenses of the alleged employee. These are real life examples of what investigators have looked at when they're evaluating whether someone was really a bona fide employee. It's really important because if you can't meet the bona fide employee exception, then you're stuck trying to meet the personal services and management contract safe harbor to protect a relationship with someone who's not an employee. And if it's a marketer and they've been paid on a commission basis, it's likely that you don't fit in the personal services safe harbor. So when you're looking at how you structure your employment arrangements with things like marketers, it's really important to keep these kinds of factors in mind and to visit with, I highly recommend visit with your legal counsel about, what does your employee handbook look like? What are your employment policies? What are you requiring those marketers to participate in? And ultimately, how are you paying them? And kind of, there's a sliding scale, I would say, of riskier and less risky ways to handle that. Let's go to the next slide. We're going to move on from the criminal statute, kickback statute, talk a little bit about the Stark law. It's really relevant only for home health, and I'll explain why that is. But the Stark law itself is a civil statute, and it's what we call a strict liability civil statute. You must comply with this law, or all of the services that are rendered that are tainted if they weren't rendered pursuant to an appropriate and compliant relationship become overpayments. And the potential penalties for violating this law are up to $15,000 for each claim submitted in violation of the law, up to $100,000 for a scheme that violates the law, denial of payment for the actual services that were provided through the tainted relationship, plus triple damages, plus exclusion from federal healthcare programs. Stark violations can get really, really expensive really, really fast. The law itself prohibits a physician, and that's an important element here, from making referrals for certain what we call designated health services to an entity. The entity in this case is a home health agency in which the physician or a member of his family has a financial relationship. So it requires some important things. One, there has to be a physician involved. It has to involve designated health services. And then there has to be a financial relationship with that physician. Again, medical directorships are subject to this law, and they are probably the primary thing that we evaluate under the Stark law. So let's go to the next slide. Just to give you a little more context for the different terms, a financial relationship is defined under this law as being either a compensation relationship or an ownership or investment interest. We rarely see physician ownership or investment interest in home health for lots of reasons, mostly because there really isn't a Stark exception that protects that kind of investment interest. We often and most commonly see compensation relationships, i.e. we see medical directorships. So financial relationship is required, but it also has to involve designated health services. That's a term of art used in the statute, and home health services are considered designated health services. Hospice services are not. So home health has to worry about Stark, hospice does not. Stark applies to a physician financial relationship if that physician will ever refer a Medicare patient to your home health agency. So if a medical director is ever going to refer a Medicare patient to your home health agency, if there's even a possibility of that, then you have to comply with this law. Again, we already talked about what the potential penalties are, but it's returning the money. It's potentially penalties on every claim that's filed up to $15,000, and the actual damages, so the value of the claims filed by a tainted relationship as a result of a tainted relationship can be tripled. So if you received $5,000 as a result of a referral by a physician that didn't comply with this law, you could actually end up having to pay 3 times that back, plus penalties, plus suffer potential exclusion. So it adds up very, very quick. Let's go to the next slide. So another thing to keep in mind is that there's a regulatory provision under the home health regulations that expressly prohibits a physician or non-physician practitioner from certifying, recertifying, or establishing a plan of care if he or she has a financial relationship with a home health agency, unless that relationship complies with a Stark exception. So if you have a medical director, physician, you must comply with a Stark exception if that physician is ever going to certify, recertify, or establish a plan of care for one of your patients. The Stark exceptions are very, very similar to the anti-kickback statute safe harbors, and that personal services arrangement safe harbor is really primarily what we think about. The commonly used Stark exceptions are personal service arrangements, office space leases, equipment leases, bona fide employment relationships. Very, very similar to the anti-kickback statute requirements. And those safe harbors that we talked about earlier. So let's go to the next slide. I'm not going to go through the Stark exceptions in a lot more detail because they are so similar to the anti-kickback statute exceptions. Generally speaking, if we can structure you to comply with anti-kickback, you will also comply with Stark, and vice versa. I wanted to just throw out a couple of your state-specific statutes that are relevant in business relations, evaluating business relationships. One is Louisiana has a fraudulent remuneration statute that's very, very similar to the anti-kickback statute and applies specifically to Medicaid referrals. It permits any arrangement that is permitted under the federal anti-kickback statute safe harbors, so that's a good thing. There is both a criminal statute and a civil statute in Louisiana. The civil statute on its face looks like a strict liability law, but its implementing regulations appear to add this knowing and willful intent requirement. I didn't dig deeply into that to see how it's been applied in case law, but it's just something to keep in mind. There's also a Medicaid fraud statute that's very similar to the Federal False Claims Act. And essentially, it's gonna, if you violate the anti-kickback statute or you violate the Louisiana fraudulent remuneration statute, it's likely you also violate the Medicaid fraud statute, and that's sort of the False Claims Act analog. So I'm going to turn it over to Ashley now. I apologize for how long I took, Ashley, but she's going to talk a little bit about compliance and interpretive guidance and how to make all this stuff a little less concerning and risky for your organization.
That's right. Thank you, Jennifer. All right. So heading towards some interpretive guidance, let's go ahead and go to the next slide. This is an overview of some of the federal guidance that has been issued or compliance materials for home health and hospice. And as you can see, if you look at the dates on some of these guidance materials, these go back many years. The first one that we have on the screen is from August 1995, which was a OIG special fraud alert that was issued for home health fraud. 3 years later, we had compliance program guidance coming out for home health agencies. And, even though that guidance came out in 1998, we still see home health providers who do not have compliance plans, even though that guidance has been around since 1998. We also have a OIG special fraud alert being issued for hospices in March of 1998. And then subsequently, a year later in 1999, compliance program guidance being issued for hospices. And then in 2015 and 2016, we also had OIG alerts, fraud alerts issued regarding improper arrangements and conduct involving home health agencies and physicians in 2016, and in 2015, an OIG fraud alert for physician compensation agreements. So as you can see, OIG fraud alerts have been issued, compliance guidance has been issued for home health and hospice for many years, but this is still a prevalent issue for many home health agencies and hospice agencies. So we're going to dive a little bit more into these guidance documents to talk through some of these issues and the application of them for your agencies. Let's go ahead and go to the next slide. All right, so first we're going to talk about the home health guidance. So next slide. Okay, so this is the OIG Special Fraud Alert for home health agencies, which, as I stated before, was issued in August of 1995. This fraud alert specifically discussed home health agencies that were offering kickbacks to physicians, beneficiaries, hospitals, and rest homes in return for referrals. Specifically was addressing hospitals with discharge planners, home health coordinators, or home care liaisons in order to induce referrals. Providing free services such as 24-hour nursing care coverage to retirement homes or adult congregate living facilities in return for home health referrals, subcontracting with retirement homes or congregate living facilities for the provision of home health services to induce referrals to the home health agency, or pressuring physicians to order unnecessary personal care services by telling them that their patients were requesting the services and that they would refer those patients to other physicians unless the physician ordered them. OIG was just identifying a number of problematic arrangements that would violate the anti-kickback statute through this fraud alert. And these are things that, are still problem areas for home health agencies, and you need to be aware of that, these things are improper. We cannot use these sorts of methods to induce referrals to our agency. Next slide. Okay, so compliance program guidance that was issued in 1998 identified a number of potential risk areas for home health agencies. So risk areas are things, areas that you need to be aware of that the OIG has identified as possibly problematic for violating federal regulations, things we want to look out for and avoid doing in order to avoid investigations and fraud allegations. So home health agencies providing incentives to actual or potential referral sources, such as physicians, hospitals, or patients themselves. For example, a home health agency paying a fee to a physician for each plan of care certified, providing nursing or administrating services for free or below fair market value to physicians, hospitals, and other potential referral sources, or providing salaries to a referring physician for services either not rendered or in excess of fair market value for the services rendered. Another risk area was services provided to patients who reside in assisted living facilities. Specifically, an issue that was identified as problematic would be a space rental that does not meet the safe harbor, and the provision of services that are otherwise covered under the resident contract or required under state licensure. And another issue that was identified was compensation programs that offer incentives for a number of visits performed and revenue generated. Next slide. In regard to home health policies, the OIG also issued guidance about policies that home health agencies should have in place. Specifically, they discussed that all the agency's contracts and arrangements with actual or potential referral sources be reviewed carefully for compliance with all applicable statutes and regulations. And that is really important to make sure that your contracts with any referral sources, marketers, medical directors, that those actually meet all applicable statutes and regulations, meet the safe harbors. You need to make sure the agency does not submit or cause to be submitted to the federal healthcare programs claims for patients who are referred to the agency pursuant to contracts or financial arrangements that were designed to induce the referrals in violation of the anti-kickback statute or other federal regulations. Again, reviewing those contracts would allow you to avoid that. And obviously to ensure that you do not provide free gifts, free services, or other incentives to patients, relatives of patients, physicians, nursing facilities. So you need to have policies on, providing gifts or offering any sort of remuneration to any of your referral sources. Next slide. And I am going to try to move through some of these pretty quickly because I know we're running low on time. But we do have all the information available on the slides for you all. In 2016, there was an OIG alert that was issued regarding the improper arrangements and conduct involving home health agencies. This OIG alert discussed practices that OIG had found in investigations and studies of home health agencies that are operating, and physicians and home visiting physician companies. Specifically discussed were criminal convictions and settlements that involved making and accepting payment for patient referrals. So as you can see, there's a common theme. OIG is looking at patient referrals, where those referral sources are coming from. Are the individuals that are referring patients being compensated for those referrals? These are top of mind for investigation. So you need to make sure that you are compliant with how you are receiving referrals. Another issue was falsely certifying patients as homebound, or payments for referring or soliciting Medicare and Medicaid patients, which sometimes involve payments to physicians disguised as payments for serving as medical director. So again, those medical director contracts, make sure you have a healthcare attorney review those to ensure that they meet the safe harbor requirements. Next slide. Okay, we're going to quickly go through some hospice guidance. First, we're going to talk about the OIG fraud alert that was issued in March of 1998. The OIG specifically stated in this fraud alert that it was observing instances of potential kickbacks between hospices and nursing homes to induce referrals of patients. Specifically, the OIG identified payments by hospices to nursing homes for room and board provided to Medicaid hospice patients should not exceed what the nursing home otherwise would have received if the patient had not been enrolled in hospice. Any additional payment needed to represent fair market value of additional services actually provided to that patient that are not included in the Medicaid daily rate. The OIG additionally identified specific practices which are suspected kickbacks, and those included offering free goods below fair market value, free or below fair market value goods to induce nursing home referrals to hospice, hospice paying room and board, hospice paying amount to the nursing home for additional services, reciprocal referral relationships, so a hospice to a nursing home in exchange for a nursing home to hospice. So as you can see, all of these are focused on overpaying nursing homes for room and board, for referrals. The takeaway from this one is to stay in your lane. Do not play games with the room and board arrangement. That's just not something you should do. It's been an issue for a long time now. It's something that OIG is aware of and that they look for when they are doing audits and investigations of hospices. So this is something that you need to avoid, and you need to make sure you have policies that cover how you interact with nursing homes, and if you have any contracts related to your interactions with a nursing home or referrals, you need to make sure those are reviewed by healthcare counsel. Next slide. So the OIG issued compliance program guidance for hospices in 1999. Similar to the home health agency guidance, there were a number of risk areas that were identified, and there were a number of policies that were discussed. So first, we're going to talk about a couple risk areas. No surprise, an issue that was identified as a risk area was paying incentives to referral sources that would violate the anti-kickback statute. For example, paying a fee for each terminal illness certification, providing nursing, administrative, or other services to physicians or nursing homes, or excessive room and board payments to nursing homes. Another one was providing hospice services in nursing homes without a finalized written agreement. You must have a written agreement with the nursing home under which the hospice takes full responsibility for the management of hospice care and the facility agrees to provide room and board. Make sure those contracts are reviewed by healthcare attorneys. Improper patient solicitation, including patient charting. For example, review of patient records in an assisted living facility without the patient's approval to essentially identify the resident population for home health, for hospice services, and sales commission based on length of stay in hospice. This may cause recruitment of long stay patients whose stays may be ineligible for hospice benefits. And on the next slide, which we can go ahead and move on to, we have some guidance on hospice policies. which is direct advice on what your policies should address, which include that all of the hospice's contracts and arrangements with actual or potential referral sources are reviewed carefully for compliance with all applicable statutes and regulations, that the hospice does not submit or cause to be submitted to the federal healthcare programs claims for patients who are referred to the hospice pursuant to contracts or financial arrangements that were designed to induce referrals that would violate the anti-kickback statute, and that the hospice does not offer or provide gifts, free services, or other incentives to induce referrals of patients. So again, all of these suggested policies are focusing on referrals of patients. This is a big issue for the OIG. It has been for a long time. So you need to make sure that the way that you are getting referrals of your patients is compliant, because the OIG is specifically looking for issues and violations of the anti-kickback statute in connection with your referral sources. Next slide. A few additional things that you should not do, things that may constitute potential kickbacks. This also came out of the compliance program guidance. A hospice offering free or below fair market value goods to induce a nursing home to refer patients to the hospice. Again, hospice is paying room and board payment to the nursing home and amounts in excess of what the nursing home would have received directly from Medicaid had the patient not been enrolled in hospice. And the hospice paying above fair market value for additional non-core services that Medicaid does not consider to be included in its room and board payments to the nursing home. Right, next slide. And this is the fraud alert that was issued more recently, but still, 9 years ago now, in 2015. This discussed a settlement with 12 individual physicians that focused on medical director payments that actually resulted in civil or criminal liability. If you want to look at the specific discussion, we do have the hyperlink available for you. But the compensation relationships were discussed and included payments that varied with the value and volume of referrals and did not reflect fair market value for the services performed. Non-performance by physicians of services called for under the agreement, and payment of salaries of physician office staff. So these are things that the OIG flagged in its fraud alert of issues that they identified in reviewing medical director arrangements. So if you need to make sure that your contracts, again, meet the safe harbor requirements so that you are not involved in a fraud investigation for violations of the anti-kickback statute. Next slide. Okay, some tips and best practices that we recommend. What can you do to avoid problems? You need to educate yourself. Do what you're doing today. Educate yourself on the anti-kickback statute, on Stark law, and what the relevant state laws are. Retain healthcare attorneys. We always say to our clients, everything that you say to an auditor or to an investigator is evidence. Everything an attorney says is an argument. So it is important that you proceed carefully. If you are under investigation, we highly recommend retaining counsel if you are under investigation or under an audit. And if you do not have a compliance plan in place, then you absolutely need to get one in place. There has been guidance available since the mid-90s on what those compliance plans should include and the risk areas that should be addressed. So if you do not yet have one in place, get one in place. It doesn't matter if you're a small hospice with only a few employees, you should still have a compliance program in place that fits and works for your agency. You don't need to have some super comprehensive compliance plan that was created for a hospital. You want to have a compliance plan in place that works for you and addresses the issues that would come up in your home health agency or hospice. Next slide. In regard to your physician relationships, make sure that every relationship with a physician is documented and reviewed by a healthcare attorney. Make sure that the document has a valid business rationale and identifies the fair market value of the services. If you have a medical director, they need to be compensated solely for clinical and administrative services. There should be no link to referrals or admissions. And really, really important is that your physicians need to document their time and what they are doing to support the payment for their medical director services. This is a very common problem when we have an agency that has a medical director where the medical director is not actually identifying the amount of time that they worked for the compensation that they received, and they're not, if they do, document the hours that they worked, they don't document what they were specifically doing, and you're going to want that to support that money that is being paid to the physician to show that there were services being rendered for the money that you're paying the physician, because if not, then the assumption is always going to be by an auditor or an investigator that you are paying that physician for referrals. Again, review your medical director invoices to ensure that the services provided and the hours worked are reasonable and comply with the contract that you have. And make sure you actually are training your medical directors on eligibility criteria, on Medicare definitions, and on compliance. You should also monitor your relationships with outside referring physicians, their offices, and marketers as a part of your compliance program as well. Next slide. We also highly recommend that if you are not screening your physician referral sources, that you do screen those physicians, your physician referral sources, and your medical directors monthly for exclusions by the federal or state authorities and Medicare enrollment status. We recommend that you check the OIG-LEIE, the available state exclusion database, and the CMS ordering and referring database. It's important that you make sure that those physicians aren't excluded so it does not taint the actual claim for the services that you're providing. Next slide. In regard to marketing staff, you need to ensure that your employees are truly employees. Consider the IRS definition of a bona fide employee. Does your company control or have the right to control what the worker does and how the worker does his or her job? Financial control, or the business aspects of the worker's job controlled by the payer, which would include how they're paid, whether their expenses are reimbursed, the type of relationship, are there written contracts or employee type benefits like a health benefit plan, a pension plan, vacation time, will the relationship continue and is the work performed a key aspect of the business? You also want to evaluate the compensation plans that you have in place for marketing employees. The compensation should not be based on the number of admissions or length of stay. Even though there is a bona fide employment safe harbor exception, we would note that many cases involving bona fide employees are still problematic. Remember the one purpose rule that Jennifer discussed earlier. Incentive payments, if any, should not be based on individual economic production. In addition, compensation for marketing by independent contractors should meet the personal services safe harbor, should be at fair market value and not based on the volume or value of referrals. It should be a fixed fee determined in advance, and contracted services should be valid services and not a cover for referrals. Next slide. A couple more notes here for marketing staff. Make sure you separate the marketing function from the intake and admission function. Intake and admissions personnel should not receive bonuses based on new patients admitted. We recommend staying away from quotas for admissions and not to fire people for not meeting their goals. Be aware of an excessive focus on numbers and revenue. Routinely check your referral patterns. Unless you're in a rural or underserved area, you really probably should not be having more than about 20% of your referrals coming from any one physician. That can be a big flag, and it's easy for the government to pull to see where the physician referrals are coming from. It's easy for them to look for that. So just be aware of that. Also, make sure you're providing training for your marketers and monitor the marketing practices of your independent contractors as well as your employees. Next slide. And one more note on marketing staff: avoid offering free or discounted services to other healthcare providers or facilities in connection with home health or hospice patients. This is really important, again, in those hospice relationships with nursing facilities. And next slide. And for your facility relationships, make sure you're documenting the relationship between home health agencies or hospices and any facility. These need to be compliantly structured, written. There needs to be a signed lease of space between the agency and any facility. If you have a nursing home and a hospice agreement, that needs to be written, signed, and address the hospice responsibility for all care and nursing home responsibility to provide room and board. And then next slide. And always, when in doubt, please ask, reach out to your legal counsel with questions, have legal counsel review contracts and consider, you know, the practices that you're considering implementing before you, you know, engage in medical director arrangements, before you engage in marketing agreements. You need to talk to your counsel first. Before you proceed, to make sure that those are compliantly structured. You don't want to, you know, just dive in and then subsequently find out that you have a problem. And then next slide, I think, is just going to be questions. And I know I went through a lot of that very quickly. So we do have the slides available for you all, and my information and Jennifer's information is available on the screen if you want to reach out subsequently to ask questions as well. We're happy to deal with questions via email and directly on the phone too. Alex, do we have any questions?
No, we don't have any questions. Thank you so much to our presenters, and thank you to our attendees for joining us today. I'll be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, please feel free to reach out to them on their email addresses listed. I hope you all have a great Tuesday.
Thank you so much.